Hello, welcome to the webinar today. As you can see from your screens, we're going to be discussing dealing with pensions after the Pension Advisory Group report with me. My name is Mena and Mark. I'm a solicitor arbitrator, and Mark Penston from Blue Sky IFAs. He is going to introduce himself in a moment. So, what we've got is general introductions to start off with. As I said, I'm Mena and Mark. I'm a solicitor arbitrator, author, trainer. My contact details are there, so if you need to contact me, then please do. I will be discussing pensions with Mark. I am a member of the Pension Advisory Group. Mark is a contributor to the predecessor of the PAG report, which is Apples and Pears, and a contributor to the Pension Advisory Group report. We've got more than 100 people registered for the webinar today. We will be on for about an hour, including questions. So you should be able to see on your control panel that there is a possibility that you can ask questions to either me or Mark by typing the question into the question box. We won't indicate who it is that is asking the question, so if you're afraid that I'm going to read out your name and your firm, please don't be afraid, I won't do that. I will just generally ask the question when Mark gets going. It will be 1 hour CPD if you are recording CPD on an hours based learning. We've got lots of people joining us today, so we've got some people from solicitors firms, we've got some people who are in a judicial capacity, we've got barristers, we've got financial planners, we've got mediators, so it's a very mixed audience. So we're expecting lots of questions from different people. I've got a couple of polls that I will be launching that I would like you to participate in, and you should be aware that there is one handout. It might be useful for you to download the handout, which is a copy of the slides, and after the webinar on Monday you will get an email from us thanking you for watching the webinar, and you will also get a copy of the webinar for the first time. So if you want to share a copy of the webinar with your friends and colleagues, then you are more than welcome to do so. You're all on mute at the moment, so the only way that you can communicate with either Mark or I is to send us a question. I've already had one question that says hello, so hello to the person who sent that to me. And I would like to welcome Mark. So Mark, welcome to you.
Hi, Mena.
One of our annual webinars, isn't it, Mark? We do one of these at least once a year, and generally on the last day of the CPD year.
Yeah, and this is in many ways a bit similar to what we do before, but it's got a PAG overlay, which we will go through. The intention is really to highlight the key areas of the PAG report. Hopefully that will whet your appetite to dig perhaps a bit deeper into the 160 pages of that report. But I think I do think it's well worth reading. Now, Mena, I think you need to give me control.
Bear with me, Mark. I think you should. Oh, there you go.
There you go.
There we go. So you've got control of the mouse.
Thank you.
And you can proceed.
There you go. So, just to talk about the objectives of the session, it's not meant to be promoting Blue Sky Chartered Financial Planners particularly, but I think as part of this process, I'll just give you a few lines on who we are and what we do. Hopefully it'll help you understand when and how you should use a pension on divorce expert, which I'm very sorry has been shortened to PODE, which isn't my doing, but we'll be using the term PODE throughout this this presentation. Of course, as Mena said, there should be some CPD. There's an hour CPD here, and that of course is one of our objectives. And also importantly, telling you some things that you perhaps need to watch out for in the process of dealing with pensions on divorce. And as I mentioned before, I'm going to be giving you some PAG headlines. So just one slide on who we are. We started as a firm of financial planners. We're about 25 years old. Since 2000, we started getting involved in pension sharing work because we always had a specialism in pension transfer work. We're all G60 or equivalent qualified. And
what does that mean, Mark? What's a G60?
The G60 qualification is in order to do final salary defined benefit transfer work, you need to have a qualification and recognised by the FCA that you can do that work, which is probably fair to say it's one of the FCA's hot topics or hot areas that they look into with financial advisors. So we've been authorised for years to do defined benefit transfer work, and I'm not sure that the FCA have caught up quite with the pension sharing world and the work that's necessary. But of course, some of the advice that is given along the way of pension sharing may well be, does the pension credit member take benefits as an internal member of their partner's scheme, or take an external transfer? And of course, that is a pension transfer under under some other guise, but we believe, and I'm going to come on to the qualifications that a pension and divorce expert is required to have. But I believe one of the important things is the person giving advice on how the pension should be shared does need good working knowledge of pension transfer work, if not have the full qualification.
Great, thank you, Mark.
So yeah, we've been doing this work since 2000. So the work we do is a mixture of pension sharing reports and possibly increasing work as a shadow expert, which I'll explain a bit later. And I've just you've got our three lovely pictures at the bottom, which is Rob and I. We're both resolution specialists, as they call them, which means that we've been through the IFA training with resolution, so we understand not only the process but the how to be what they call a financial neutral in your roundtable meetings. And Jeremy, who's currently going through the process of accreditation himself.
And I believe, Mark, if you don't mind me interjecting, that although the resolution accreditation scheme for IFAs has been going for quite some time, there are now only 20 of you who are accredited financial planners within that scheme. So it's quite something to have two of you, and possibly three of you when Jeremy qualifies, all of whom are accredited, because it's quite tough now to get hold of an accredited financial planner.
Yeah, which of course we're all delighted about, but I think in all seriousness, I think it would be good to have a few more people who step up to that mark over a period of time.
I agree. Yeah.
So look, we run these sorts of sessions quite a lot, and these are all the questions we get asked typically. I'm going to attempt within the hour to run through most of them, and purely by the nature of the large range of questions, I'll only be touching lightly on most of them, but hopefully this will give a good overview of things you need to think about and a bit of guidance on the pension sharing world.
So, Mark, just before you move on to this slide, I'm going to take over and launch the first of our polls about the Pension Advisory Group. Everybody received a copy of the link when they registered, or should have received a copy of the link to the Pension Advisory Group report, and I had put a copy of the link in the chat box. So if anybody hasn't seen the link, it's there. But I am going to launch a poll, and I would like everybody to answer as honestly as possible. So the first poll you will see is open, and the question is, have you downloaded? My preference is always for downloading rather than printing a copy of the Pension Advisory Group report. Your options are yes, no, or you've printed it. Don't be afraid to say that you've printed it, it's fine. But if you could answer that question, and while people are answering that question, I just wanted to say that the membership of the Pension Advisory Group is really wide. I'm the Law Society representative on the group, and we've got lots of different people. The Pension Advisory Group is spearheaded by academic Hilary Woodward, who you were involved with, Mark, when you did the apples and pears report before this started. We've got solicitors, we've got barristers, we've got judges, we've got 4 academics who were extremely helpful in writing the report. I'm sure the solicitors on the line can understand that getting 20 odd people to try and write a report together would be really difficult. We've also got some PODs, so acknowledged PODs, on the group. We had a representative from the Institute of Actuaries, so a really broad group of people. It's not all big money, big London type of work. So we've got lots of different people who are available and who contributed over 2 or 3 years. Now I can see 82% of people have voted, so I'm going to close the poll, and I can see that about 50% of people said that they have downloaded it. 23% have said no, they haven't. And to those people, I will say, can you please try and download it? You don't have to do it now, but obviously by signing up to the webinar, you've indicated an interest. So downloading a copy of the report's a good idea. And if you've printed it, that's fine. 27% of people have. But it's actually, I think you and I have had this conversation briefly at the launch event, Mark. It's actually quite useful to have it as an online document, isn't it? Because it's a searchable document. So if you were looking for something in particular, you could use the facility on the document just to search, and it doesn't have, as I think you pointed out, it doesn't have like a good index at the back that you can use to find things, does it?
No. No, and I think I think the first thing to say, it's not guidance necessarily at this stage as to how pensions should be shared on divorce, but it gives an awful lot of context and technical detail around pensions in the context of divorce. So I think anyone involved in divorce and sharing assets and sharing pensions should have this to hand, because it's a free reference document, I think, which is very useful.
Yeah, and I think that a lot of people will find that it's hugely useful when it comes to Mark, are you still there?
Yeah, I am. Yeah.
Oh, I seem to have lost my screen for some reason. We won't worry about that now. I'm going to launch another poll, if that's okay with people. I had a really bad experience with my last webinar, so I'm slightly concerned. But the next poll that I am launching is for those people who have answered yes, they have either downloaded it or they answered that they had printed it. Can you answer the next question, which is this? If you have a copy of the report, have you read it? And as you may know, Mark, people, particularly solicitors, I think, have a habit of taking away and printing copies of things, and having the sort of safety of knowing that they've got that document, but they then don't actually read the document, which isn't
I think we're all guilty
terribly.
of that, Mena.
Yeah, it's not particularly to solicitors. I just happen to know that in the old days of Law Society gazettes being distributed as hard copies and people going to courses and getting hard copies of notes, the notes would be proudly displayed on a bookshelf somewhere, but actually never read. So I'm going to 61% of people have voted, so that's most of you. I'm going to close the poll and I'm going to share the results so that you can see that there are of course some people who've said that they haven't read it, and that's fine because it may be that you've recently downloaded it, but of course it is something that you do need to do. 29% have skimmed it, and I would say that to those 12% of people who haven't read it, skim it to begin with. There's an initial executive summary that's really worth having a look at. Some people have read parts of it, and 5% of people, gold star, have read it from cover to cover. So we've got a number of knowledgeable people, but of course the whole idea is that you read you read that report, because that's super important. So I'm going to hide the results of that poll, Mark, and I'm going to share my screen again because I think that the screen might have stopped sharing. There we go.
That's great.
So
That's great. So getting back to the pension advisory group, that document again, and the issues, their headline issues. I just need a bit of control, Mena.
Yeah, there you go.
Okay, there you go. Of course, the headline issues here are that it's common knowledge, I guess, that pensions are often the largest asset that you'll be dealing with on divorce. So they're an important item. It's an important item to get right. But what the apples and pears, this all started with the apples and pears document that Rhys Taylor helped produce. And that ascertained that there was a big inconsistency of approach as to how pensions were dealt with in divorce, and that can create confusion and maybe some distrust in the industry. So this whole process was to try and educate people, because generally there's a lack of understanding in the legal profession about pensions, and why should you have a deep understanding of pensions? Because that's the work we do. We don't have deep understandings of the legal system. So you are often having to face with a complex pension issue, which I guess you've got to be careful how you deal with. And of course, a barrier to many in the legal profession trying to get too much of an understanding about pensions is the legislation is very complicated. Some of you may remember pension simplification in 2006, which of course was a long time ago, and many people will say, well, the legislation around pensions now is even more complicated than it was when the government brought in pension simplification in the first place. So
yeah, and this is mentioned by Sir Andrew McFarlane, who writes the foreword to the Pension Advisory Group report, that really there's a need to have some understanding about the basics, because sometimes people have picked up habits that don't actually pertain to the rules or what's happening now. They might pertain to rules that have now gone, and so it's really important, because of the complex legislation, to have a consistent approach from Devon to Newcastle. It's really important that everybody's doing the same thing, which they don't seem to be.
No. And so the aim of this document is to try and clarify the process of dealing with pensions on divorce, so that your financial remedies are going to be as fair as possible between the parties involved. And I think this is a great first step in helping the profession understand what it's dealing with and the general approach that should be taken.
And it is a first step, because it's intended that this report will be updated over the years. So this is, the first thing, but we're not just going to let it lapse from the Pensions Advisory Group point of view. Yeah. It should be updated in years to come.
Yeah. So just some warning headlines. Where should lawyers take care when dealing with pensions on divorce? And remember, the first thing here is, well, you've sent off, or your client's given you a bunch of valuations. The first question to ask yourself is, how do you know that valuation is fair, or is it correct? Would you know how to spot errors? So one has to be careful that that you know what you're looking for, and once you've got those details, do you need a pension sharing report? And we're going to be covering that in a moment. We're going to try and give you some guidance on, well, do you even need one in the first instance? The point here is, and Mena's going to chip in a minute on this, because we've on our website, we've got a suggested disclaimer, because we think it's important that if you've recommended to your clients that they should get a pension sharing report and they say no because it's too costly or it's going to take too long or whatever, that your clients sign a disclaimer to say that they've been advised to have one and they decided not to. And I think the backdrop of that is because of the litigation which is beginning to, or is already emerging around pension sharing where people have been given advice, maybe often from their lawyer, which has subsequently turned out not to be the right advice. So
Yeah,
that's why
that's
we've
right.
launched the disclaimer. But Mena, I know you have a little bit to add on this, don't you?
That's right. In the Pension Advisory Group report at Appendix W, we have thanked Grant Lazarus of Harrington Chambers in Liverpool, who provided a paper to us, but that paper was then subsequently published in the Family Law Journal, and I can't remember if it was February or April of this year, but it's called "You Keep the House, Love, I'll Keep the Pension," and if anybody has the opportunity to hear Grant speak, then he speaks, very knowledgeably and in a very entertaining way about professional negligence. And most of us wouldn't think that professional negligence is interesting. But what his view about disclaimers, which has to be the right view, is that he would say that most disclaimers are not worth the paper they're written on, purely because what most solicitors are doing, and I can count myself amongst those solicitors, having changed my practice on getting the information from Grant, is that what we do is we've got a standard disclaimer or a disclaimer that we tweak that says you don't want a pension expert's advice, you don't want a shadow expert's advice, you're not going to go to a financial planner, you want me to implement this pension offset maybe, and Grant would say that 100% of the work that he's done is in relation to offsetting negligence work, or whatever the client wants, and we say fine, we'll draft the consent order if that's what you want, but we can't give you any advice. And actually Grant's truly intelligent view is that you can't do that. If you or I, Mark, went to a surgeon and the surgeon said, well, you need to have one of these organs out, there are going to be consequences, and stopped there and didn't tell you what any of the consequences were, we couldn't then give informed medical consent to the surgery. And it's no different in the legal context, which is that if we say to the client, well, we'll do what you want, we'll do the consent order, but we can't tell you what any of the outcomes are going to be. We can't give you any advice. We can't point you in the direction of any things that might go wrong. For example, the offsetting of a final salary pension is fraught with difficulty, then they cannot give informed consent. And if they haven't given informed consent, then any disclaimer that they sign isn't worth the paper it's written on. So yes, use disclaimers, but those disclaimers have to be used in conjunction with advice to the client regarding the pensions that they will understand, and only then can we afford ourselves a modicum of protection. And I don't think that is the general consensus among solicitors, who often say to me, but but the clients don't want it, but the clients can't afford it, but the court won't order it. And in fact, none of those things will protect you in a negligence claim.
Yeah. Yeah.
I'm sure we'll have a barrage of questions, but we'll, by all means, if people have got questions, send them in and we'll take them at an appropriate time. But please do access a copy of Grant Lazarus's article. It was on the Family Law Journal. I don't know if he's published it on his Chambers website, but I think it's out there if you have a look for it.
Yep. Thank you, Mena. So one of the other big warnings, and of course hand in hand with this, really, I guess, is don't stray into the area of giving financial advice. It's very easy to do so, whether you're talking to a client about an investment policy they have, or a pension. And what we often find is that decisions are made, or advice is given, or general sort of, well, I think this would be all right to do, is that sort of advice is given without the understanding of what's perhaps underneath the bonnet of that pension or investment that you're dealing with. And on the point of giving financial advice, what the PAG report talks about is, even when you're completing the pension sharing annex, and section F is a box where you can tick whether the pension share should be dealt with as an internal transfer or an external transfer, you advising the client which box should be ticked is financial advice.
Yes.
And that's, as I mentioned before, that's pretty close, or perhaps is you giving financial advice to a client as to whether they should stay in a defined benefit pension scheme or transfer out. So I think it's quite important there.
And I think it's really important because solicitors do this inadvertently. They will inadvertently, because the clients don't want to go and get independent financial advice, or they don't know how to do it, or they think it's going to be, supremely expensive, they just won't go and get advice. And then we're forced into a situation. This box isn't a mandatory box that we need to tick, but sometimes we do too much for clients. Let's pause there for a second, Mark. We've got a question, if you don't mind.
Yep.
Let me see if I can get this question up. We've got quite a lot of questions actually. What's the starting point when asking clients to provide details of their, and then I can't see the rest of that question, which is slightly annoying. Bear with me, Mark. Let's carry on, then I'll try and get the rest of that question together. So that
Okay, I think maybe, Mena, if you keep your eye on the questions, what often we find with these sessions is that the questions get answered as we go through, because there's a few slides to go through yet. So let's see where we go.
Okay.
So are you all right with that, Mena?
Yeah, that's fine. Yep. I'll leave you to it.
So point 5, as Mena's mentioned before, is most of the negligence claims on pension sharing have been in offsetting cases, and it might well be where it's been decided that one person has a house and the other person keeps a pension as some kind of amicable trade-off, and then subsequently one party or the other decides that it's been a bad deal, and that's where negligence comes from. Now I think, Mena, you need to let me.
No, you should be all right there.
There you go. And the other thing that the PAG report talks about is that they recommend that a lawyer doesn't close their file until they know that any agreed pension share has been implemented, because that's actually part of the process. And what we found is that there are many cases where the solicitor thinks they've done the job, case hasn't been implemented, and it's created issues further down the road. So as our involvement in pension sharing, we're very keen to make sure that everybody is aware of the process and the progress of this pension share, and that you don't close your case until you know it's been implemented.
I mean, it sounds really straightforward, doesn't it? But I know from my perspective, I had a difficult one that you had given the experts report on, that we just couldn't implement it, and I just had to keep that file open for years. And it's not what solicitors want to do, really. But once you close it, you'll forget about it. So there's no point in closing that file.
We're often asked a question on do you use an actuary or an IFA? There's a few slides on this sort of stuff, but that's a big point, and I'm simplifying this, I guess, but the world of pension sharing reports and inquiries often start in our world with a telephone call, or even we have solicitors come and talk to us about their cases to say, I've got this case, this is what it looks like, what do you think I should do? And then, of course, often the central of all this stuff is getting a pension sharing report done and instructed, and that's what, of course, is where often a pension on divorce expert's life starts. That's where they get their first inquiry, and then at the other end, once you've agreed to things, it's the implementation of that pension share, and maybe and often the client will need some kind of ongoing financial advice. But the point here is what typically an actuary will do is they will be instructed to do the number crunching stuff in the middle. How should we share the pensions given a set of parameters, and that's what you get. That's what you get from an actuary. What you'll generally find with a financial planner, or a financial planner who is well versed in this market, is you'll be able to have a discussion up front to say, this is the case, what should my letter of engagement look like? What questions should I be asking, and what questions shouldn't I be asking? And I think that's, in our experience, that's been a really useful dialogue to have, because it means that when we are then producing pension sharing reports, it's a very focused a set of answers you're asking, and you'll get, a set of questions you're asking and a set of answers you're getting. And then as the financial planner, if relevant, we can even help with the implementation, and indeed we've written some case studies where actually the advice in the pension sharing report was also included how that pension share should be implemented, because there were very specific steps which needed to be taken in order to implement that pension share in the correct manner that didn't, in this case, create very big tax bills because of lifetime allowance issues. So the point here is you have a choice as to whether you want that shortened format, if you like, from an actuary or indeed a pension on divorce expert, or do you want it in some wider context? And that's the work we do. But because we are blessed with quite a bit of work and we didn't want to get overrun with work, we've decided as a business to divvy up the cases that we do deal with where we think we can add value, and the ones that we don't deal with. And so as a business, we don't deal with uniform services or the teachers pension scheme or the NHS or local government schemes. And the reason why we don't deal with those schemes is because they only allow internal membership on pension sharing. Now, that then means that it's a fairly simple number crunching exercise where one party will share their scheme, resulting in their spouse becoming an internal member of that same scheme. It's not much financial planning can be done around that. It's a fairly simple it can be a very complicated calculation, but it's a fairly simple process. Whereas the work we focus on, because I think we do that much better, is that we will deal with larger value schemes where there's maybe lifetime allowance issues. I'll come on to that a bit. Or there's complex schemes, or there's multiple schemes where financial advice will help that case and will enable us to be able to consider the permutations that give the best outcome for both clients. So
and sometimes it's true, isn't it, Mark, that you might have a financial planner doing the report generation, but then because they have been involved in the report generation, they're an expert, single joint expert, they then can't do the individual advice to the client. So you might have a POD and a shadow expert in some cases, because so you might have two people involved in different capacities.
Yeah, absolutely. And I think the POD, who is an IFA, can often be used as that shadow expert. So, we do pension sharing reports, but if we aren't doing that report, a solicitor can instruct us to say, well, I've got this pension sharing report from somewhere else. What do you think? What does Blue Sky think? What's the best options? How should I deal with that? And also underneath that, of course, is our work with resolution, where we act as a financial neutral. And some time ago now, I wrote an article with David Lockett of Actuaries for Lawyers in the Resolution Review magazine, which was this was actually pre the PAG report, and it talked about, do you use an IFA or do you use an actuary? And of course, what that article concluded was, well, it didn't really matter whether you use an actuary or an IFA to get the pension sharing report. What was important was, are they pension on divorce experts? And it's great to see that that's the outcome, that's the conclusion of the PAG report anyway. I'm going to skip through these slides because those are, if you're downloading that, you can read this. I just wanted to
just a checklist of when people can use a POD, and it's important to note that in the situation that you were just talking about, that if you were the expert, the report writer, then you couldn't be in the same case the shadow expert, because you are independent in that case. But I have used you as an expert in one case and as a shadow expert in another case, which means that you're an expert, but you're only acting for my client. And it may be that you're interpreting a report that's been provided by somebody else, which sometimes I've needed in the past. So you wear many different hats, don't you?
Yeah, and for us, shadow expert work is quite good, because that's where we can add a financial planning overlay to the actuary's report of the pension sharing report that you've got. And I suppose, just to conclude, that actuary or IFA, in which actually I don't think it matters. However, finding a pensions expert is important, and if you've downloaded the PAG report, you'll find in Appendix D this, what they call this self-certification of experts. So there isn't any one qualification which would demonstrate that you can do this work, but you go through each one of these items, and if you're looking for a pensions on divorce expert, they need to have ticked all these boxes for you to know that what you're dealing with is a person with the right qualifications. And I've ticked those boxes because I'm delighted to say that we do tick all those points.
It's also worth mentioning on that point, Mark, that lots of people are asking me as I go around the country talking about pensions and doing CPD updates, oh, why is everybody so busy and where can I get an expert? And actually, everyone's so busy is because there's just a lot of reports being written and not enough experts, but also people tending to use the same experts over and over again. Whereas if you can get your expert to self-certify that appendix, then you can rest assured that they can write an expert's report. And I think people are a little bit uneasy sometimes using somebody they've never heard of before, but that's a good way of doing it. And I encourage everybody in every case to ask their experts to self-certify in accordance with the PAG report, because I think once we get used to doing that, then we'll know the rogues as they come up, so it will be easier.
So just moving on, do I need a pension sharing report in the first place? PAG covers this quite a lot, and makes the point that, of course, saying the parties have agreed to ignore the pensions isn't your get out of jail card, really. They view it as not an option. And their headline is, well, if the combined values of the pensions are under 100,000, you probably don't need one, because the cost of getting a pension sharing report is possibly a bit too prohibitive. That's all a bit arbitrary, and it's then covered with caveats, because, of course, if the values of the schemes are under 100,000, first of all, do you know that the valuations you've got are correct? And a lot of defined benefit schemes, final salary schemes, uniformed services are traditionally, historically undervalued. The value of those schemes don't really represent the true value of the benefits. So you might think you've got schemes under 100,000, but actually they're worth a lot more. And the other point with a lot of money purchase schemes is that there can be hidden benefits underneath the bonnet. So you might have a valuation of a personal pension that is not that big, but if it's got guaranteed benefits, guaranteed growth rates, then it may have an implied much higher value than might be evidence. So I think one has to be careful of that.
And it's worth repeating that the Form P is really important to get those other benefits. Getting a Form P completed in a case can be helpful to kind of widen the net when it comes to information. The Form E pensions page is a starting point, it's not an end point. So the Form P is really useful.
Yeah. So under that, do I need a pension sharing report? Well, the summary, I guess, is we're not always, but get a disclaimer signed if not, subject to the stuff that Mena said on that. There's always this cost of a pension sharing report versus the benefit of getting one and the risk of not getting one, and that can be difficult, it can be challenging, and that's why a lot of the work we do is have those discussions up front to say, where you might give us a case scenario, we'll do a quick triage to say, I think it's worth doing one, or I think it's not, or this is the cost, so we can help with that. Our view, and the PAG's view, is you've got to be careful with high value schemes, multiple schemes and complex schemes. And I mentioned before about the lifetime allowance, which is how big can those pension funds be, and are there lifetime allowance issues? I'll talk about that in a minute. as I've mentioned, hidden benefits. And if you've got, as lots of cases do, have many different schemes, then sharing those schemes to produce equal incomes can be created through many different options if there's lots of schemes. And some of the challenges we have is we have a sit down and scratch our head to say, well, we know how to divide these schemes to produce equal incomes, but which is the best way of doing it? Which gives
And that's really a financial planner. That's a financial planner input, and it's got nothing. It would be going into the realms of giving financial advice if we as solicitors said, right, well, this scheme looks like it's worth 100 and that scheme looks like it's worth 200. We'll just divide that scheme, and there's another scheme that's worth 50. We can't do that. It's not a simple process, and I know solicitors on this webinar would probably not do that in a million years, but perhaps there are solicitors who are in this quandary of clients who don't want financial advice but want us to do everything. We need to learn where to draw the line.
Yeah, indeed. So look, just a quick slide. This is a complex area, but I just wanted to highlight some points because we are seeing more and more cases where the client, one or sometimes both of the clients, have pension funds which are over the lifetime allowance limit and therefore subject to extra consideration. And the key points here, what this graph shows is, well, how the government have year after year changed and meddled with the lifetime allowance limit, starting at 1.5 million, going up to 1.8 million, and then down to 1 million. And now what they have said is, okay, we're not going to meddle with it anymore until the next government maybe gets in, but we're going to increase this £1 million lifetime allowance limit by CPI. So how do you work out whether a client's affected? Well, if they've got a DC scheme, as we call it, so a money purchase scheme or a personal pension, that's what I mean by that. So if it's an invested fund, so you take that fund at face value. If they've got a defined benefit pension, teacher scheme or something like that, you take that annual pension that they've accrued, times it by 20, and add the lump sum which they're likely to get from it, and you add all that together. And if that pot of money is over currently 1.055 million, there's going to be a lifetime allowance issue.
And it's a good indicator, isn't it, for solicitors and mediators who are listening to this webinar to say, well, actually, this would be a red flag to say, oh, these parties not just have to be told to go and get planning advice in mediation, for example. If this came up, possibly you would be saying to them, you need this advice, and there could be money saving here in terms of pension sharing going forward, or arranging the finances so that it's financially positive for the person who may be over the lifetime allowance. So it's not just knowing what it means, it's knowing what it means and how to deal with it within the course of either negotiations as a solicitor or mediation, so that people understand that this is not only an issue, that it's an issue that parties can get some sort of benefit from if they're thinking about it at that stage where they're negotiating.
Yeah, and I think one of the keys here is that we're seeing more and more of these cases, and one reason why is that if the lifetime allowance limit is only increasing at CPI, if you've got pension funds accruing at anything faster than CPI, which at the moment they are, then you're going to get more and more clients creeping into this lifetime allowance issue, and therefore probably just to talk a bit about the motivation of the issues here, is that if you come to retirement and you take benefits which equate to more than lifetime allowance limit, one of the tax options is a 55% tax charge. That's quite draconian. So you wouldn't want to be making recommendations to any client which knowingly would put them into that tax charge, where there possibly could be ways out of it. And it's a massively complicated area, I'm afraid. It's further it's further complicated by the fact that when the governments kept changing the lifetime allowance level, they allowed people to then say, well, we've changed it, but you can protect yourself at your current level. So there's all forms of protection and enhancements to the lifetime allowance which a client may have. So as long as asking a client about their fund value, you also need to ask them that have they ever applied for lifetime allowance protection, which bizarrely some clients don't even remember doing. So that can be a complex matter itself.
But for solicitors, it's knowing the numbers and then moving to a point where they know what to do with it, and mediators as well, which is, ensuring that they know when to ask for a person like you as a shadow expert. And somebody has just said on the questions, what is a shadow expert? A shadow expert, is somebody like Mark, so he's got the expert's credentials. He's not writing a report. All that Mark is doing is working on the part of your client to say either there is a report, what does it mean, and how can we make the best of the lifetime allowance problem, or how can we engineer the different options in the report so that they benefit, or that there's the best case scenario for our client, and their sort of input doesn't come into the court arena. So it's somebody just sitting in the background giving you some advice, maybe looking at a report that has been produced and saying to you, well, these are questions you want to ask the expert, or just giving you some help in the absence of an expert's report, just for your client. So not a single joint expert, not jointly appointed by the court, sitting in the background giving some help, which I think is important. So a shadow expert sitting in the background, whereas an expert of the court, or even somebody, I know you do, Mark, write POD reports if people are in mediation, and they can approach you to do a POD report to assist them with the mediation going forward. So that's important. I know that you want to talk about when you need a pension sharing report in the next slide, and we've got some examples that I think are useful, Mark. So I'll deal with the other questions towards the end.
Yeah, and I mean, just very briefly to add to that, the typical scenario might be a lawyer that refers cases to us to say, Mark, I don't want Blue Sky to do this report. I want someone else to do it, but they want to engage Blue Sky to help them and their clients. So if you like, we sit in their back pocket when they've got a pension sharing report elsewhere, and help them to disseminate it and help their client through with it.
Or even help to write the single joint expert's letter. Yeah. I think that's something that's really useful if you've got something very complicated. And by complicated, I don't mean big money necessarily, just complicated pensions.
Yeah. So I just want to run through a bit of an example here, which hopefully answers a lot of these questions. And this is a client that we dealt with some time ago, who worked for a retail firm quite high up. You can see here that their projected salary, or projected pension rather, was about £85,000 per annum. So a nice big fund, and this is where the wife was a high earner. Pension statement shows about £85,000. Now the quoted value, the quoted CE, was about £900,000, so £880,000. Now I've got to be careful how I say that, but a very, very rough rule of thumb when you look at these things is, well, what is the multiple of the income, that's the pension income, what multiple is CE? And in this case, it's just over 10 times. Now, so £85,000 times by 10, that's where you get to that. Now, the range of multiples that we see probably ranges from about 10, so this is probably one of the lowest ones we've seen, up to 70, so 70. So that kind of gives you an idea. Now, probably the middle ground might be 25, 30, 35. It's that sort of area that we typically see. And if we see something as low as this, we will then obviously go back and talk about, well, was it correct? Was it fair? Is there a mistake? And in this instance, what we found was that, having gone back time and time again, yes, this was fair. What this means is, I think I've got, okay, I'll just come back to this. What this means is that if you look at the CE and find that it's under £1 million as quoted by the the company, if you then say, okay, well, that's fair enough, but what's the revenue valuation for this?
For the
Then
lifetime allowance.
if you times a pension by 20, you'll see that's 1.7 million. So this client's got a big lifetime allowance problem.
That doesn't mean we're using the lifetime allowance valuation as the CE. We're just looking to see, because it's a different calculation, isn't it? So you're just saying, as a rule of thumb, you need to look at both the CE and the lifetime allowance for valuation figures to see how you deal with it going forward.
Yeah. And of course, just to put this again into context, is that if you look at the cost of buying an £85,000 pension on the open market, that cost would be 2.8 million. So that's just goes to show how low this pension valuation indeed was. A key point here from our financial planning aspect, our pension sharing work, is that you've got to share a load of this pension in order to give the husband, in this instance, enough of a pension to create equality. And if you shared the valuations equally, which is, in my opinion, a big no-no, and I don't know why anybody ever asks this question. We regularly ask questions: how do you, if you divided the C's equally, what would be the outcomes? That's this is the sort of thing you often get, where the wife will have a pension of 42,500, the husband has got half the CE accredited to him, and he ends up with 18,000. Just don't do it. I don't even know why we get asked the question.
And it has to be said, in the pension advisory group report, the recommendation is to do income sharing, not capital sharing. I think solicitors have this tendency to want some safety numbers, so they ask all the questions, Mark, but you're right. I don't think that we necessarily do that much with the information that you give us.
Yeah, I'm kind of aware of that. And so if we did our number crunching, as we did, we showed that the husband would need 68% of the pension in order to create equality of income, which was £26,500. So you can see she had to give a big wedge of her pension to the husband. This was a very amicable case, and one of the questions that they asked was, well, how can we make this? How can we give this a better outcome? And I'm conscious of time, so you might have to sit and think about this. But what the client said is, well, look, if I wanted to retain an extra 10% of that pension, so I didn't have to give away so much, what else would I have to give away in lieu of it? And what we decided, and crunch the numbers, is that the wife had moved to another quite big house, and she undertook that she would sell it by the time she retired, and she would give her ex-husband a percentage share of the equity in order to compensate him for that. And if you ran the figures through, the benefit of her retaining 10% extra pension was equated to nearly a 10% return on her money. So my point here is that if we're given the ability to, in our pension sharing reports, to say, can we consider different scenarios that might help the outcome for both people, and if we can engage with people in that manner, and I fully understand that we can't all the time, but you can get some great outcomes.
And I think that the takeaway for people listening to this, whether they're barristers, solicitors or mediators, is getting a financial planner involved early. And I know this was a sort of a collaborative style case, is a really good idea, because these are the types of solutions that you can come up with that suit the parties. So whether it's in mediation or collaborative, the parties will lead what it is that they want to do, and you can give them lots of options in your position, in that case, as a financial neutral, helping both parties outside of the courtroom situation.
Yeah.
Mark, as you said, we're running a little bit short on time, so we're coming up to about 5 minutes. We will carry on, and then if people can't stay, we're sending a recording to those people. But it might be just worth having a quick look at these questions, if you don't mind.
Yeah, go for it. Yep.
So that people help understand what it is that we're trying to do. So if we're acting for the client with the larger pension, should we make Part 25? Oh, I'm having problems with my questions, Mark. I really am. Should we make Part 25 applications, I think, for the FDR is the question. So if it's somebody who's acting for the client with the larger pension, should they be applying for a pension expert to be appointed in that case?
Well, look, I always think yes, because well, why wouldn't you? Because how do you otherwise get to a get to a fair outcome? Because if you're saying to your client, well, you've got a big pension, try and sit on your hands and keep quiet, then surely there's some obligation for the lawyer um, uh, to say, well, no, you know, the guiding principle is you've got to share the pension. How do you know what to share unless you get a report? So, what are you going to offer, and how will you know if you have got a large pension, or if your client's got a large pension? How do you know what he needs to give away that is fair?
I think the idea is that if that person's got the larger pension and the other person's got the smaller pension and they haven't asked for an expert, then you could probably do a broad brush calculation, so almost sort of sweeping it under the carpet. I mean, my worry with that is how would I know what to offer of the larger pension in the absence of any financial advice? So
Yeah.
even if I didn't ask for a POD report, I'd need to have somebody like you as a shadow expert sitting in the background, and then the person who receives the offer, how do they know whether to accept? I mean, the solicitor making the offer and the solicitor receiving the offer are really putting themselves in a position of, potential negligence in making or receiving offers when they don't really know what the outcome is. So you need to have at the very least, a shadow expert sitting in the background, if nothing else. But I think that you're just putting off the inevitable if you don't
Well,
ask for an expert to be appointed at a first appointment.
Well, or the other thing, you'll find in the packs on one of my slides. I think it's slide 26. Just one slide on. I often talk about cash flow modelling, and we do deal with quite a lot of cases where they haven't instructed a pension sharing report. One side has said to the other, "Okay, you can have 40% of this pension," and the other side says, "Well, I don't know what it means to me." And one thing that really helps cases like this is let's do a bit of cash flow modeling for that individual to see if the offer from the other side is enough.
Yeah, and I
And
find that really useful where I've done that.
we've had cases where we've modelled the husband's offer of 40% of his pension, and the wife has sat there in our meeting with her, and we've managed to say, that's enough. You know what you want to retire on, and that pension share is enough. So you can either go and fight and spend more money on proper reports or whatever, or if you're happy with that, that's enough money for you. Do you want to fight for more? Then it's just such a useful piece of work without having to go to the full cost of a pension, full cost and time of a pension sharing report.
Mark, I've got one last question, and what I will say to the audience is we are going to send the video out. So if you can't stay past 2 o'clock, then rest assured that we'll send the rest of the video out. And Mark and I are just going to carry on if you've got the time to do that, Mark, for about
Yeah,
maybe 10 minutes.
we'll
One
fast
last
forward. Yeah, go one last question.
Yeah, one last question. So the question is about lifetime allowance, which you were talking about a moment ago. So if your client has protection regarding lifetime allowance and there is a pension share, does it impact on the lifetime allowance protection? And will the recipient of the pension share have a tax liability?
Uh, well, that of course depends. So I think the first point is that it won't affect the lifetime allowance of the person who's if the husband's got lifetime allowance and he shares the pension, then it might well be that it doesn't affect his lifetime allowance. So if he's got lifetime allowance protection of 1.5 million and he's got a 2 million pension fund, he's over his protection. If he gives some of his pension away, it might bring him below his lifetime allowance, which is great. The wife will have her own lifetime allowance. So you can see that in big cases where the wife receives a large pension share, she might suddenly have a lifetime allowance problem. And one of the interesting points we won't probably cover too much now is whether the report you ask for takes into account lifetime allowance issues and trying to equate income, including some consideration of lifetime allowance tax charges, because we do see reports where lifetime allowance tax charges aren't taken into account in pension sharing reports. And our personal view is that probably more should be made of that fact.
Okay, let's move on to the rest of the presentation. Well, there are a couple of more questions, but we'll come to them at the end
right.
as we carry on. So why CEs are misleading is a very popular problem.
For efficiencies of time, I can say, look, these are copied from the PAG report, direct copies, and you can read through these at your leisure. But it's really just to say that sometimes the CEs aren't what they seem. If you've got two CEs, if your husband and wife have apparent equal CEs, you can probably, and you might think, well, that's okay. You just keep what you got. It's the key here is, will they create equal incomes? So they might have the same CEs, but will they create equal incomes? I think I've lost control again. And the other issue is when we're sharing, we're doing pension sharing reports, is we will try where possible to not only create equal incomes, but to create equal risks. And what I mean by that is to try and give both parties, where possible, benefits that have similar levels of guarantee if they're defined benefit schemes, or if they're money purchase schemes, to give them similar levels of pension funds that are exposed to investment risk. So that's another dynamic we'll look at. This is another example from the PAG report, which is sometimes what we see in schemes, that you might have one client with 750,000, another client with or their partner with 500,000, and therefore you'll say, well, let's do an offset where the wife in this, or the husband, would receive £250,000 of non-pension assets. Doesn't work like that. It won't create equal incomes. It won't necessarily, probably nearly always, won't create your expected outcome. I'm going to skip through that. That's a bit on offsetting. We do separate sessions on offsetting. Just wanted to cover pre and post marriage accrual of pensions, and this question we get asked quite a lot, and understandably so, that that one party might say, well, a lot of my pension was accrued before I got married, so I want to exclude that, and I understand that. What the PAG report talks about is that if it's a needs-based case, then actually the courts have the ability to resort to any asset, wherever it is, whenever it is accrued. And so that's one aspect, that if it's a needs-based case, a court could quite easily say, well, I'm not worried about the pre and post marriage stuff.
And we discourage the questions being asked. In fact, that's what PAG is saying. Don't ask when you're doing a POD report to exclude premarital or post separation, because if it's a needs case, then it all goes in the pot.
Yeah, and absolutely. And the other thing that's difficult for anybody who does pension sharing work is, well, okay, if you do want to exclude pre-marriage work, pre-marriage accrual, then what was the level of your pension at the date of marriage? And of course, most people, when they were walking up the aisle or whatever, they hadn't had the thought process of saying, well, just in case I get divorced, I ought to get a pension valuation that I will file away somewhere. So we are then, the pension report producers are then making estimates as to what that pension valuation was likely to be 10, 15 years ago. So it's a horrible piece of work, and in our view, and in the PAG's review, is probably of little value. In the PAG report, you will find a great section on state benefits. Our view is always include state benefits in pension sharing work because they can be quite a significant part of the assets. They're much easier to get now because you can get instant online pension state pension forecasts, so you don't have to wait for the BR19 form to come back.
And it's worth saying, isn't it, Mark, in the state pensions, particularly in the mediation stages that I'm seeing, that because the Form E doesn't require the disclosure of the what's referred to as a basic state pension, at that stage you're often not seeing people getting the forecasts at the mediation or the voluntary exchange. But actually it's super important, particularly in low money cases, because it's going to make a huge amount of difference, isn't it, in the long run. So everybody should read the state benefit section in the PAG report because it's really very important.
Yeah, it's very good, and then it actually, I reckon people who read that would find it of some academic interest themselves to say, oh, well, I'll go and have a look to see what my state pension is likely to be, because also on the same website there's a tab which will show you your NI record, so if it's you can spot if there's things which might be incorrect on it. So it's quite if you're a bit of an anorak, it's quite interesting. A lot of people already know this, but it's often worth mentioning the timing of the decree absolute and the pension sharing report, the pension sharing order. And the point here is that the pension sharing order takes effect on the later of the 7 days following the period for appeal or on the date of decree absolute. And the issue here is if you date the pension sharing order the same time as the decree absolute, you now have a situation where the pension sharing order isn't yet effective, but the spouse is no longer a spouse. So if you've got a client with a big defined benefit pension scheme that would have paid a spouse's pension, and the spouse and the spouse, you're now divorced, the spouse is no longer a spouse, and if the member of the pension dies, the spouse hasn't got any spouse's benefits, and the pension sharing order will fall away, so they're left high and dry. And so there's some real issues. And in the 20 years we've been doing this work, we've had 2 cases where we've had to deal with inconvenient deaths. Not that there's probably ever a convenient death, but from a timing point of view, it was inconvenient.
I've met at least 4 solicitors who've fallen foul of this. I also came across 2 very senior barristers who had no idea back in the day when you could, at a final hearing, say to the judge, can you also grant the decree absolute, which you can't now, for very good reason. And some of the delays at the divorce centres will help to mitigate against this, getting the decree absolute too soon. But of course, if the parties have done an online divorce and already got their decree absolute, there's nothing you can do, apart from highlight the danger of what they've done already, for which we won't be responsible for. But if you are in charge of applying for the decree absolute, do really bear this in mind. There should always be 28 days between getting the pension sharing order. And everyone says, well, we want to get on and implement, but it's much more important that the order is effective, and the explanation for that is in the PAG report, and you have to sit with it in a quiet room for a little while to understand what it means. But this is just to highlight to everybody not to get the decree absolute as soon as possible.
Yeah. So I suppose, and we're on a home run now. Can I close the case? Yeah. Our view, PAG's view, is make sure that the share is implemented correctly and to conclusion. Well, that's typically where you may have then handed that piece of work over to a pension and divorce expert who should keep you informed. They can spot the problems because pension trustees in some cases aren't very aware of what they need to do and when and how they need to do it. And if your client doesn't implement, then the pension trustee can implement to a default scheme on your behalf and or on your client's behalf, which can not be what was intended. And a lot of pension and divorce experts who are financial advisors can help their clients look into the future to say, right, you've had your assets halved, you've got this pension share, what does your financial future look like? Next bit, I'll mention cash flow modeling, which we use more and more, particularly in, offers made, is it enough? Or if I give away this much pension, am I left with enough? So that's quite useful. And of course, it's quite a good visual aid to use in court for perhaps the time-starved judge, barrister, or lawyer to be able to see quickly and effectively what a proposed scenario will look like in the future.
And I think this is brilliant in mediation as well, frankly, for the parties to understand what an offer means is really useful.
Yeah, and this is obviously the world according to Blue Sky, but our view is when we do financial planning, pension sharing reports, they're based on the same philosophy that we produced financial planning reports for our non-pension, non-divorcing clients, which is to try and make our reports get to the answer pretty quickly. Get to the answer simply, so you don't have to dig around for, well, what is the number I'm looking for? And as you will see on this slide, we display our answers in grids, so you can see what it looks like. We actually use graphs where applicable to say, well, this is how you share the pensions, and this is a profile of the pensions, perhaps up to the date of retirement. And our appendix will always have a section in that says, well, if you're going to implement the pension as per the report, this is all the details you need for your pension sharing annex. So you'll have the scheme name, policy number, all
and this
that.
is so important, Mark, having been at an FDR and settled a case according to a report that you had written. We were able to fill in the pension sharing annex while we were sitting in court without having to wade through the files to get all of this information. We were just able to transcribe it over into the pension sharing annex, and I think that's so important because it's such a lifesaver. After negotiating for 6 hours at an FDR, the last thing I want to do is to try and find all that information in my file. So having this is really useful.
Well, I mean, and this came from A, popular demand, but B, a case we had where the client had 6 legal and general pensions, and we wrote a report as to how to share them. And the actual completion of the annex by the lawyer completed the wrong policy number in the pension sharing annex, which caused all sorts of problems.
Well, it will. Once you've got your decree absolute and you've got your order with the wrong pension and sharing annex information, it's really difficult to change that.
Yeah. And just very finally, what you'll see on our website is there is a resources page, and we were asked to do this piece of work by a YRES, young resolution members, to say, look, we don't really understand the difference between a money purchase scheme and a final salary scheme. What do you mean? So this is a Janet and John, very simple, and our compliance department could probably pull this to pieces, but it's just the headlines of what's the difference between a final salary or money purchase scheme, and all the terminology that's used. That's on our website, and I think.
If we leave that slide there, Mark, what I'm going to do while people look at your summary is just to look at the questions, if you don't mind. Oops. If I go back a bit, is to look at the questions, because I think there might be a couple of other questions that have come in since the last question. We've still got the majority of our group still with us, so I think it would be quite useful just to go through those questions. So someone said that the PAG report is an outstanding piece of work, which is great because it means they've read it and they like it, and I keep encouraging people to read it. One question from a mediator: what should be the starting point when asking clients to provide details of their pension in terms of valuations? What's the starting point, Mark?
Well, If they're going to do it themselves, they could use the wording to say, please could they provide a valuation and statement of benefits. So those two things probably are the key: valuation and statement of benefits for divorce purposes. So let the trustee know that you're considering divorce, and they'll
And the statement of
probably,
benefits is very important, and is in addition to the cash equivalent
it is.
value. Yeah,
And
and
it probably means they will hit their, pension on divorce button, which will generate their standard bump. Might not give the POD everything they need, but it will be a great start.
And of course, the PAG report has got things to watch out for. So there's a checklist of things to watch out for in part two, I think it is, that you can just have a quick look at it and say the minimum data. So when in page 13 of the PAG reports looks at gathering information and disclosure, and at 2.5 looks at the minimum data that's needed, and then the form P, which provides additional information. So that's a good starting point for valuations, isn't it?
Yeah. Yeah.
We've answered the question about Part 25 reports. We've answered the question about shadow experts and lifetime allowances. What should a solicitor ask the single joint expert to look at? Is it equality of income, and at what point in life? Is it wife's retirement, husband's retirement, or a date in the future? What do we think, Mark?
Our preferred option is that you look at producing equality of income when all pensions have come into payment. Now, so that would be at state retirement age, which is generally the latest date, because so what we want to know is that when state pensions have come into payment, that the pensions will be equal, because up until that stage you may have created unequal pensions. And so that's our preference, because that creates most clarity. If you think it through, there's too many other permutations if you do everything else. If you say, well, I want to create equal incomes at 65, well, yeah, that's fine. You've created equal incomes at 65, but as soon as 67 or state retirement age comes along and the state pensions get paid, you've now fallen into unequal incomes.
I should also mention that there is a draft letter of instruction in the Pension Advisory Group appendices, and there is some discussion about that point, which is, what do you put in your letter of instruction? So whoever asked that question, and for the rest of you, please do look at the letter of instruction and please do use it. Of course, the committee of the Pensions Advisory Group drafted that letter, which is at Appendix E, and it's bound to be, a committee of 20, including High Court Judge, bound to have including a full-time High Court judge and 2 part-time High Court judges, I should say, deputies, bound to have drafted something better than anything that you can come up with on your own. So do use that. Don't wish to embarrass you, Mark, but there is a question about the cost of a Blue Sky pension sharing report. Are you able to say a range?
Yeah, right, this really depends on the questions asked and the nature of the scheme, but our costs range from about £2,000 upwards. I would think typically it's probably around the 2,000, 2,100 mark, maybe, and I would say, well, it's a particularly complicated one, might be 2.5 or north of 2,500.
And I would say that I've used Mark as a single joint expert over the last 15 or 18 years, and I've never had any problems in getting hold of him. And I know lots of people have got issues with experts and getting responses or getting replies to questions. I've never had that problem at all. And of course, you saw the example of his report being straightforward. So you don't need anybody else to interpret it for you. So that's worth mentioning. One final question, I think, Mark, if there's a possibility of enhanced annuities due to ill health, would that always indicate a report is necessary?
I just wind back a moment, Mena. I just wanted to mention that it's very kind of you to say about us and our accessibility, but people should know that there are 2 other people in the office who are
Yes, of course.
very conversant on this subject, and it's not just Mark Penson, it's also Rob and Jeremy. You got the details at the front, but the answer to the annuity question. And again, the PAG report covers this. And I think it makes a very valid point that if your client is, let's say, in their 40s with some kind of medical condition now, or maybe they smoke, the debate is, do you apply impaired annuities now, given that the fact they may stop smoking or they may recover? And that, I guess, is down to the particular pension sharing author, pension sharing report author.
But does it mean that the report is always necessary? So that's the first question. Is a report always going to be necessary if there's ill health and enhanced annuities?
Well, yes, because I don't see that it's anything different. It's the driving factor behind whether you need a pension sharing report or not is the size of the pension funds and the nature of the pension funds. I'm not quite sure. I would say, well, it's dependent on the individual states of health, unless perhaps there's a dynamic where there's a very short life expectancy for one member, in which case that really is a case for a financial planner to then sit down with the client or whatever and say, well, what are the death benefits which are knocking around here, and what are the death benefits that would be lost or be made different
So perhaps a case where you're a shadow expert, or there's a financial planner as a shadow, and then that financial planner can give some firm advice in every individual case as to how to proceed forward, always bearing in mind that that financial planner has to have some help, some expertise in divorce work. This is absolutely the final question, and it is a form of nepotism. What are Blue Sky's current timescales for delivering a report, Mark?
Well, the one-liner on this is our timescales are currently 3 weeks after we've received all the information necessary. Don't underestimate that last bit of the sentence, because some pension trustees are particularly awkward or slow in providing us with the information. But once we got all the information, 3 weeks, and we've and this is to repeat, I guess, one of the points in the slide is this is because we have been quite careful about the cases that we take on and where we can add value and where we can retain pretty good turnaround times on our pension sharing reports. So if people want to know whether we can do a case, they need to give us a buzz or send us the information or email us information, and we can produce a fairly quick estimation of time and cost.
Thank you very much, Mark. It's been great speaking to you again. Thank you to everybody who has stuck with us, even though we're 20 minutes over time.
Pleasure.
Of course, it's all CPD that's claimable. Mark, you've also got a couple of courses coming up, haven't you? If people want some more training from you, where are they? Can you say, or have people received emails from you?
One's in Reading, one's in Newbury. You can look on our website. The information should be there on the website, or get in touch with us.
Of course, Mark's always happy to do more training. Get in touch with him. I do training on pensions and financial remedy work, and of course I'm an arbitrator. We haven't even mentioned arbitration, but of course it could be useful if there are pensions involved. But thank you very much, everybody. We'll draw the webinar to a close for today, and of course we will be sending everybody a copy of the webinar in due course. Thanks very much, Mark.
Thanks, Mena. Thanks. Bye for now.
Bye.